So
there's another case too that.
What's the other case?
Well, there's another case in Cecil that says basically the same thing, that it does recognize that the bus driver does not owe a duty to a passenger once they have safely alighted from the bus, if there is under normal circumstances. They did grant summary judgment because there was no issue of material fact as to whether there was a foreseeable zone of risk. They specifically stated that.
So how do you respond to that?
Can you repeat that? The reason why that court granted summary judgment because there was no dispute as to whether there was a foreseeable zone of risk. Here, there is an issue of whether the foreseeable zone of risk has been established by the relocation of the bus stop, and to whether Mr. Gossard owed that duty to warn and protect Lisa Marks because of the new location of this bus stop.
She is no longer a common passenger on this bus. She has departed. There is no duty. Regardless of the situation, there is no duty.
Well, it seems like there's some case law that suggests that the situation does make a difference.
Well, my case law suggests that she's no longer a common passenger. Once departed, there's no duty unless there's a specialized circumstance, unless someone takes on this duty.
This is a specialized circumstance. That's the issue.
No, it's not.
But do you have anything that suggests that it's not when the plaintiff is alleging that a change in bus stop with a passenger getting off, walking to the back, to use a crosswalk at the back as opposed to the front, and the front versus the back, is in itself an unusual situation?
It's not unusual. Everybody has to use ordinary care regardless of when they're crossing the street. If someone wants to cross in front of a bus, if somebody wants to cross behind a bus, use ordinary care. It's really not a factual dispute.
But no one's suggesting that ordinary care is not being used. That's an issue, again, that goes to comparative negligence.
Right.
I guess the question for the plaintiff is, do we have a definition of what unusual circumstance is?
A specific definition hasn't been laid out, but an unusual condition such as the relocation of the bus stop could be classified as an unusual condition. It could be classified as a foreseeable zone of risk because this isn't the normal bus stop.
Well, couldn't anything be classified as an unusual condition?
Correct.
So then that kind of torpedoes the argument that the duty ends at the time of the passenger getting off the bus.
Yes.
And in the
Counsel,
case,
I'll give you the final word if you can.
in the case in Pivotal, first of all, it's a completely different circumstance. This woman got off the bus and tripped the actual sidewalk.
Well, let me stop you. Counsel, you just said that you didn't get the case. Are you saying that you do now have the case?
I have the case here.
The case is cited in your motion, correct, Counsel?
Yes, sir.
You
This-
received his response.
I'm looking at it right now.
Okay.
This is completely different from our situation because this has nothing to do with her crossing the street. Has nothing to do with her getting hit by a
I don't
car.
understand.
This only has.
It has nothing to do with their crossing the street or getting hit by a car.
I'm
You
talking
mean
about,
Pivotal
I'm
did?
talking about Pivotal.
What did Pivotal have to do with it?
Pivotal is just a woman got off the street where the bus stop was a very bad place. She tripped when she got off. It was a bad street. They sued the city as well. The road was bad. In this situation, the road is not bad. There's nothing to do with the road. She crossed the street, gets hit by a car. These are two completely different situations. And as you said, there's no definition as to what brings this in. It's open to interpretation. This interpretation does not fit our case.
Well, now this is interesting. I was going to end the argument right there, but let me just go back to plaintiff one more time. Now he's saying that Pivotal involves somebody getting off a bus and tripping on some defect in the road or the bus stop itself. And the court found that that did not constitute an unusual condition?
No, because that was the normal bus stop. This bus stop was changed by the defendant himself to temporarily relocate the bus stop due to construction. And they didn't provide a sufficient warning or protection for their passengers, clearly because my client got struck by an automobile because she could not see ongoing traffic.
Are they then suggesting that the plaintiff and Pivotal, because it was the normal bus stop, knew of the problem at the normal bus stop?
Well, the city isn't necessarily, I don't know if the city or the bus driver was the employee of the city, but I know the bus driver is an employee of Coach Lines who changed the bus stop, giving Mr. Gossard the duty. He should have been on notice to protect and guide Miss Marks across the street.
All right. Defense counsel, give you the final word.
Final word is this. There was no duty. This was not a dangerous area. There was, she's no longer a passenger on the bus. There's no duty, and case law cites that once a person departs from the bus, crosses the street, and gets hit by a car, there is no liability. And also, let me state one more time, she stood there for 1 minute. 1 minute in time, 60 seconds. Anybody can cross the street, see their surroundings, look around, 60 seconds, that is a substantial amount of time. Even if it was 1 second, there's still no duty. But 60 seconds, please.
I think, here are my thoughts, all right, here are my thoughts. Your argument picked up as you got more into the argument, as you became less self-conscious about it. The only thing that sticks out in my mind is something that I thought, man, you don't see this a lot, is you don't typically call your opposition misguided. Okay? You shouldn't say he's misguided, all right? Because it's a little bit of an insult to them, it's a little unprofessional. But everything else about what you did was professional. Now, on Sam's side, I think Sam did the correct thing in that when you're faced with the, in this argument, where you're faced with the basic issue about whether it's a fact question, if it's an inherently more dangerous bus stop, you go right back to the case law, which is your safe haven. So you make an argument that's something like, look, Judge, I don't have to get into all of that crap about whether one bus stop is more dangerous than another. The case law says I don't have to get into those questions because my duty ends. The problem is that at one point, you made it look like you didn't know anything about the pivotal case because you said you didn't have it, right? The court would pick up on that. Now, in this instance, I knew you had it because I gave it to you, right? So you did have it. I know he cited it because it was one of the more important cases. But then also, you should refrain from talking to him directly. So you can't, I mean, you can, but it's bad form, and the court won't appreciate it if you turn to him and say, remind me of what the deposition testimony was, or remind the court. Or,
What's the name of the case?
Or if you say, if he's making a point to the court turns to you and says, how do you respond? And you say, repeat what you just said. The court kind of looks at that like, hey, you only got 15 minutes. We can't be repeating ourselves all day.
Yeah.
So you really should refrain from talking directly to him. It's very interesting, though. You guys are, compared to the group before, you're a hot argument. You're not upset with each other, though you do seem to kind of, and I think it's because you haven't done it, graze a little bit into each other, because you're aggressive, Sam, so you're you're pointing at him, you're asking him questions, and you're like dismissive of him.
He's like, he's a
misguided statement. But again, I think you both did an excellent job, and I think your instincts in both areas, the way you handled the argument, is the correct way to do it. There's just a little bit rough around the edges. I mean, Sam could not wait to get into his argument. He was probably out in the hallway 10 minutes before, and he knew exactly the point that he wanted to make, and he was just going to keep poking at the same spot in your arm until your arm wanted to fall off, which is why when I asked him to give me a recitation of the facts, he gave me about 2 facts, and he went right back to what he was going to say anyways, right? I mean, you could have said, the facts are that on this day, the plaintiff was on this area, and was on this bus, and they got off the bus, and the designated crosswalk, which was an alternate spot, but instead you said, she got off the bus, there's absolutely there's no question she got off the bus, and she was hit. And it wasn't our fault because our duty ended. I mean, you're right into the duty in the case law in about 30 seconds. If you watch the video, you'll see.
And that's bad.
But that's not bad, it's just that's what you wanted to do. Now, if the court really wants to get into the facts, though, he might just keep pestering you about it. But overall, I thought you both did a very nice job.
Thank you.
All right, so you're done, and I'll see you next Monday.